Hello and welcome. Thank you for joining, everybody. I'm Tom Nayland, the Head of Risk and Policy at the FATF Secretariat, and today I'm going to be talking with a very distinguished panel about beneficial ownership transparency. This is a subject FATF has been working on since the first standard on this area in 2003, and it's long been recognized that transparency about the ownership and control of companies is a key tool to prevent the misuse of them by criminals and terrorists. We've had standards for some time, but we've found that countries aren't applying them very well. Only 9% of countries have effectively implemented the laws, and that even when they do, those rules haven't been enough, as we've seen with revelations from the Panama Papers, the Pandora Papers, and a host of criminal cases and media investigations. So in 2020, the FATF launched work on amendments to our recommendation 24 to strengthen beneficial ownership transparency, and we adopted those changes in March this year. So today we're going to be looking at what the risks are, explaining the changes that were made and giving an insight into why, and looking at the implementation challenges that we all have ahead. We've got a very expert panel with us today, and I'll ask them to turn their cameras on now while I introduce them. First up, we have Emile van der Does de Willebois from the World Bank, who is the coordinator and head of the Stolen Asset Recovery Initiative. We have Chiara Bacci, who's an expert from the European Commission's Financial Crime Unit. They're both insiders who've been deeply involved in the FATF work on the revision of Recommendation 24, and they'll be able to share their insights into why some of those changes were made and what they mean. And we also invite critical friends who can give us a wider perspective on these changes and why they matter, and occasionally point out what we missed. We have Isabel Scherf, who is the Global Head of Financial Crime Compliance at Fidelity International. And we have Professor Michael Levy from Cardiff University, who's got a very long-term interest in this area, and I think probably needs no introduction because half the people in this seminar have read his books or papers. So welcome to our panel, and thank you for joining us. The way we're going to structure this webinar is by first jumping in to talk about the risks, and then we will move on to the key changes in the revised standards and the rationale for those and the implementation challenges. This is going to be an interactive discussion. We have a Q&A box for those who are taking part in the webinar. So if you have questions, please ask those using the Q&A box. We will be monitoring that and putting those questions to our panelists as the subject comes up or as the discussion moves on. Otherwise, we're going to try and be relatively fluid, and I hope address all of your main questions in the course of the discussion. Let's start out with a look at the risks, though, and I'll turn to you first, Mike. Why corporate transparency matters? How are companies being misused, and what are criminals doing with the system as it stands to move illicit funds around?
Well, I suppose anti-money laundering is basically about trying to stop bad people, bad countries using their own names or bad companies to do bad things. And those things include fraud. Oscar Wilde once wrote that it's only by failing to pay one's debts that one can hope to remain in the memory of the commercial classes. But of course, if you're using somebody else's name or somebody else's corporation, that's easier to do, and it doesn't leave you with the bad reputation unless your involvement is revealed. So it's partly about fraud, which, as we know, in most of the countries around the world has been rising. It's partly about drugs, human trafficking, and all the other ills that FATF tries to combat. And why wouldn't they use a company rather than their own name? So this is not a recent problem, but the FATF is trying to get us all to take the misuse of the corporate form a lot more seriously than we did, and trying to do that at a national level and at an international level. But only recently, less than half of the countries that have been evaluated were rated as largely compliant.
Thank you. Let me turn to you, Emil. A few years ago, you authored or co-authored the book on the puppet masters, which gave a wealth of information on the cases that we were seeing of misuse. What trends have you been seeing recently about the misuse of companies?
Thank you very much, Tom, and good morning, afternoon, evening to everyone. And thank you very much for inviting Star to speak on this panel. But before we get into all the evils that are being done with legal entities, I think it's helpful because as AML professionals, we tend to maybe have a bit of a jaundiced, distorted view of the world and only focus in on the small part that is bad, and tend to forget that, of course, in the large majority of cases, the use being made of companies and any type of entity is entirely legitimate. Just as a sort of health check, that we don't think that this is the entire universe. There is a much wider universe out there, and that's important when it comes to particularly risk assessments and things like that. Now, within that universe of bad actors and AML, as Mike just said, the transparency of corporate entities is absolutely paramount. In the vast majority of large money laundering cases, you will see that there is a corporate entity, a company, or some type of other, typically for-profit, it can also be non-profit, entity that is being used to shield the involvement of the persons of interest, of the beneficial owners. And that is true whether you're talking, as Mike was just saying, whether you're talking about tax evasion, whether you're talking about organized crime, whether you're talking about terrorism financing, or indeed whether you're talking about corruption and kleptocracy, and particularly that issue of corruption and kleptocracy to us as the World Bank and as UNODC is of paramount importance, given the devastating effects of corruption on development and on the development of country. Now, there's a lot to say about it. One of the issues I'd like to sort of highlight as far as the characteristics of, you were asking about, what sort of trends, the characteristics of a lot of this dispute, typically, not always, but typically, is the multi-jurisdictional nature of this sort of abuse. And what I mean by that is that you will find that the structure has been devised so that different parts of information are typically available in different jurisdictions, precisely in an effort to frustrate law enforcement efforts. So you'll have an entity incorporated in one country with a service provider in another country, maybe a nominee in a third country, and maybe the assets in another country. And typically they're not just one corporate entity, but a whole host of corporate entities. And that multi-jurisdictional nature, I think, is terribly important, and also explains why this should be the something for the FATF as an international body to take forward.
Thank you. That's very helpful. I guess if it was an easy problem, we would have fixed it already. But it's also interesting to highlight that this isn't just money laundering, it's tax evasion, corruption, and a host of other bad behavior. Chiara, let me turn to you now. From a regional policymaker's perspective, which of these risks are you most concerned by?
Thank you, Tom. And first, from my side as well, good morning, afternoon, evening to everybody, and thanks for organizing this. I think I can only join what you all have already said in terms of what triggered this and the problems that we see in terms of corporate abuse by criminals. Let me just come in with one figure from the European Union, and I'll quote a recent report by Europol on serious and organized crime threat assessment that basically tells us that 80% of criminal syndicates in the Union are actually using corporate vehicles for perpetrating their activities. This gives you a hint into the magnitude of the phenomenon and how important it is, if you are serious about preventing and fighting organized crime, to tackle this specific area. And let us also think about the wider context. We are in the recovery from a pandemic. We are in a situation where the economic system is facing difficulties, is very weak, and the risks, not even anymore of infiltration, but really like colonization by organized crime of the legal economy are very significant. And in this context, it is truly a priority that we are able to protect the economic system, but our society is more at large, by ensuring that we do actually have adequate transparency tools in place for corporate vehicles.
So this is something that goes right to the top of the political priorities at a government level. But on the private sector side, turning to you, Isabel, what are the risks that you're seeing around misuse of companies, and how well are the current preventive measures working?
Yeah, and I think I'll have to, and by the way, hi everyone, I'm thrilled to be here, and hi to everyone who's watching. I think it's important that I first say my firm is active in asset management. It's important because, you know, different firms, different sort of products, activities attract different type of potentially abuse by criminals. I think personally, one of the main areas, and you know, very prominent over the past couple of months, is sanctions and potential sanctions evasion. I think a very hot topic on a lot of people's mind at the moment. Also what Mike said earlier about fraud, for sure. I think, you know, we see different vulnerabilities or different type of cases depending on the jurisdiction, depending on what type of business we conduct. Some of it is very low risk, others is not, so we need to put more effort towards it. But there's definitely a multitude of things. I think it's important to also recognize that, you know, we're all collectively working on this, but we cannot forget that criminals that are trying to abuse the systems, and systems like financial system is doing an awful lot of good, is there for good reasons. But, you know, at the same time, there are rapid developments, and we need to make sure that we do our best to stay on top of evolving trends, technologies that are being used, and how criminals actually do it, because only if we understand how and where our risks sit, can we do something about it. And I think understanding your own activity, your own client base is absolutely key to that. Thank you, Tom.
Thank you. You've given a perfect segue to the next section of the discussion. I wanted to go into some of the things that have changed and why those changed. And to give a quick recap for everyone, there were a lot of new elements in the revised recommendation. We have a risk-based approach for the first time, which is exactly what you were just mentioning. We have controls on foreign legal persons. We have a multi-pronged approach so that there's more than one kind of information and more than one place to get it. We have BO registries or alternative mechanisms for those. We have adequate, up-to-date, accurate information, and we have some new provisions on who should be able to access it, including public procurement authorities. And last, we have controls on bearer shares and nominees, and I hope we can get into all of those issues now. But to pick up on Isabel's point, I'll go to Mike Levy on this. The risk-based approach is a new element here. We've heard that the risks keep evolving. How important is a risk-based approach in the context of beneficial ownership transparency?
A risk-based approach to all things is a really good idea. But in every sphere, it's actually quite difficult to implement because it's often very hard for the users of the system to work out, you know, what kinds of risks, how serious those risks are. And in the real world, people often differentiate between the risks that they're going to be punished for getting the judgment wrong and the risks that are out there from the bad behavior. And that's a circle is very difficult to to work their way through. But I think in principle, it's a really excellent thing that risk-based approaches are brought in. The difficulty that not just FATF, but everybody has at a national level as well is, well, what do you do about things that seem to you to be low risk? And because countries and regulators and the FATF itself are very reluctant to say, well, actually, don't worry about that. Focus on this. They're very good at saying, focus on this. But what you actually reduce, unless you're going to have an infinite expansion of resources to deal with these risks, is a trickier problem for risk-based approaches. But I do think it's a very good thing. And we have to accept, coming to Emil's point earlier, those risks may differ from if you're trying to pick up a kleptocracy case from if you're trying to deal with a modest drugs trafficking case. And so, yeah, if you go through the risk-based approach seriously, as we are encouraged to do, we have to think, well, what kind of crime is it plausibly that might be being committed here? How do you distinguish between voting rights and ultimate beneficial owner economic rights? Yeah, is somebody just using the director they claim is a ultimate beneficial owner as a front person for the activity because they don't want to be revealed? So all of those issues are really important risks to try and handle.
Thank you. So understanding the risks properly as a starting point, and I'll come to Isabel in a minute because there's an implicit challenge in what you said for the supervisors, that we need the companies to understand the real risks rather than just the risk of being sanctioned or fined by their supervisor. So Isabel, how do you balance those two objectives of yours?
So first of all, when we write policy, I'll speak for myself, but also for the team and the company I work for. I don't think we worry about sort of which regulator gives out the biggest fine, because quite frankly, it's irrelevant. Because if we pay 10,000 euros or 25 million, just personal perspective, the end of the day, it's a reputation on the line. We want to do the right thing. We want to be seen as doing the right thing. And quite frankly, customers would be concerned if we wouldn't have our house in order. And they would ask questions, and we have boards that are concerned about it. So I think, being afraid of a regulatory fine is sort of a thing to consider, but it doesn't range, like probably not even on the top 3 of my personal list. Because you'd also find that the larger the firm, the actual, the easier it is for them to pay the fine. Let's also be realistic about that. I think the fine in itself is not going to ruin you and cause sleepless nights. It's what's coming with it. That is the concern. And I think, ultimately, what Mike said earlier about a risk-based approach and not having unlimited resources and being from the industry, I feel that point. I think we all do. And also be realistic about it. I would want my team, the teams in the business, to focus and really focus on the risky things. That does not mean on the less risky things we do nothing, but there has to be a little bit of balance, because we also see that, it all of a sudden becomes this, who can collect more documents, who can tick more boxes on a sheet. And, whilst maybe superficially towards a regulator, you can show all these papers and all these boxes ticked, realistically speaking, you're probably not going to achieve much, and you're probably going to miss the important things buried in checkboxes and in pieces of paper. I obviously don't mean printed out paper, I mean electronic paper, because I don't think a lot of companies are still using paper files. But yeah, that would be my point on that, Tom.
Thanks. This comes up every time we discuss any of these new issues, that in order to do more on one high-risk area, it's meaningless unless you can do less on some of the low-risk areas. Talking of the high-risk areas, I want to come to Emil next, because the risk-based approach that we've just introduced on Rec 24 for the first time singles out foreign legal persons as something that countries need to look at and understand as well as their own. What's the thinking behind that, Emil?
Thank you very much, Tom. We're very happy to see that focus on foreign legal persons, precisely because of the sort of multi-jurisdictional nature of the issue that I mentioned earlier. This issue almost invariably crosses borders, and to think that one country can solve it only within its jurisdiction without taking into account how it is exposed to other entities that have a connection to that jurisdiction, to not take that into account at all, I think would be foolhardy and not realistic. There are multiple examples of particularly types of IBCs, of international business companies, that are formed under the jurisdiction, under the laws of one particular international financial center, but that are administered in lots of different other countries. Previously, we said, well, that's the concern of the specific international financial center. Now I think we're more realistic in saying, well, if you have, for instance, classes of lawyers or accountants who are offering these instruments, these types of companies, in a large way to their clientele, you as a country better shape up and get to know about these animals that have some connection to your jurisdiction. Now, it's going to be, I think, don't know how far we want to get into the implementation challenges, but of course, at what stage does a certain type of foreign entity become a concern for a particular country? Obviously, one swallow doesn't make summer. One particular instance isn't enough. You have to see at what stage there is sufficient connection to your jurisdiction. And I think that is something that in the course of implementing this, we're going to be having a lot more discussions of what are the types of connections that we're looking at. Does there always have to be a real connection to the jurisdiction, or is it simply, if I as intelligence unit or as a law enforcement body see this entity come up again and again and again, maybe then it's a good idea if my country starts to learn about it. And I think that that as an idea, we're very happy to get behind and very interested to see how this is now going to be implemented. And we're doing that in our own risk assessment of legal persons, rolling this out and seeing how it's going.
Thank you. And we'll come back to this very soon, because doing risk assessments of these things for the first time is one of the biggest implementation challenges that countries are facing. Before we do, I want to come to Chiara, because one of the things that we've done in the revised standard is put in a multi-pronged approach. So there's no longer reliance on a single source of information. Perhaps you could tell us what's the thinking behind that, and how is the Commission putting this into the next money laundering directive?
Thank you, Tom. And indeed, I have to say, from our perspective, this is one of the most welcome changes in the standard, and something that is very important to make sure that we come to what we ultimately want to achieve with this standard, which is on the one hand to make sure that you're able to prevent, like we discussed, the misuse of corporate vehicles, but on the other hand, that whenever law enforcement and financial intelligence units need to access that information, they have the sufficient certainty and confidence so that the information is of good quality. And that is how you can achieve that through the multi-pronged approach. So you mentioned, indeed, we're coming from a situation where we had one or more methods or possible channels to now codifying what is something that in the EU we read for some time, but it's a broader spirit here, basically three, let's say, approaches. The company approach, the information held or obtained through a register or an alternative mechanism, and any additional mechanism that a country might need to implement on the basis of risk. For example, customer due diligence performed by the private sector. And the way that we see it functioning from the EU perspective is that you want these different prongs to actually function as one and to have them interact with one another. One of the solutions we had is this discrepancy reporting. So whenever you, as a private sector operator, identify that the information you have is not consistent with the information that is held in the register, you will report that. And again, the ultimate objective of that is to make sure that ultimately information is consistent and correct, and that law enforcement authorities can actually rely on the information that is provided to them. So it's really about having confidence that what you receive as information actually corresponds to reality. And that's like an extremely important element when you are actually trying to shed transparency on corporate vehicles.
Thank you. That's very useful. I'm going to turn to the rest of the panel and see who wants to jump in on the subject of registries, because that's the key new element of the multi-pronged approach that you mentioned. We've had a couple of comments in the Q&A, one of which is, what does this new legislation mean for protection of personal information? But I'll also ask a wider question, which is, what's the emerging experience that you have of how registries are operating? Isabel, you were first on the buzzer.
Yeah, I mean, first of all, I think the idea and the concept of registries is great. It's fantastic. I think, you know, from an industry perspective, we'd obviously also prefer to be in a position where we can actually rely on the data and not have to do like go to the client who will, well, probably tell you the same thing that they put on the register, and go to additional sources. Again, on a risk-based approach, that is a no-brainer to do this. But you know, in every single case, is it really weighing the risk? It's a question. I think from the perspective of using registries, yeah, concept is great. We've also seen, you know, some countries who've been really open and making it easy for users to actually use them, i.e. the information is available in English, at least to a large extent, and not just in local language. You don't have to, or where you don't have to create a user to log in. Because I think, you know, again, this sounds like a bit of whining, but realistically speaking, if you have a global business and let's say you're doing business in 35 countries, that's another 35 logins that you need all of your team to have, all of your team to remember. And it would, of course, be much, much easier. And some countries, won't name names, have done that. And that is great, right? It's an additional measure to access data. But yeah, in other cases, it's difficult. And it's even difficult to get permission. But I equally appreciate data protection concerns for individuals. I think it always depends on the level of information that is out there.
Thank you. And yes, we've heard lots of proposals from techno-utopians for a single global beneficial ownership register, which are both magical but also terrifying. Let's turn to Emil and your experience, and then I'll come to Mike straight afterwards.
Thank you, Tom. Yeah, I think obviously Europe is far ahead of a large parts of the rest of the world. So our experience is probably lagging a bit compared to what other panelists can say on this. But what I do see, a lot of the countries that we work with, is the traditional approach of the registry is basically still archival. We put in our registry what we get from others. It's in the interest of companies to make sure that that information is correct, because it is mainly to facilitate trade. So it is mainly to allow contractual partners to verify is this person able to bind the company, and can I do business with him or her? And so it's in the interest of the company to make sure that what is in there correct, but it is not, and that mindset, that switch hasn't been made in most countries that we deal with, where you say, well, now you're not just going to be accepting what you get and putting it out there, you're going to have playing a more active role. A few countries where we do see that work is where the registry is somehow attached more to a supervisory institution that already has that sort of mindset. But in a lot of countries, I foresee challenges. But as I said, I think Europe is far ahead of others. So I should probably leave others to speak about this. Thanks.
I can see Chiara looking pleased at that. Mike, what's your picture on this?
Yeah, I mean, I think historically, registries were seen as a profit center, or at least not as a loss center for the country involved. What the FATF is now requesting, demanding, what the international community is now, including the private sector, is now demanding, is that stops, and that it being treated as really a global public service center, in which you are providing information not just to your own nationals, but to international people, from investigative journalists to corporate service providers. And that's a big psychological challenge for a lot of, and economic challenge, because ideally what it might mean is registries being able to, and some countries are doing this, to link the information in their own registries to other sources of information, and to actively test, in the words of the US in a different context, trust but verify, and to actively test the veracity of what's in there. And the reporting back mechanism has caused a lot of difficulties, in different countries have different practices in that regard, but partly it's an issue of data privacy, because you can think that data might be manipulated to falsify the register by third parties if you allow it to be too easy. On the other hand, data privacy is really dead, and I think we should be upfront about that. That if you want to operate through a corporate setting, one of the trade-offs is that you give people access to that. Now, there can be problems. Let's assume you're in a kind of animal rights arena. You might get some vindictive, or in a corporation that has affected other states, you might have attacks. So what are we going to do about all those? It's a big problem, and there haven't been any solutions. But I'd say even within the EU, there's a lot of variation in how much countries offer, and whether they offer only to their own nationals with ID numbers, with national ID numbers, or whether anybody can have access.
Yes, this is an issue which we had long discussions about when we were revising the standard, and there's no good answer on a compromise like that. There are a couple of questions that we've had through the Q&A, and I want to see if some of the panel can answer either or both of them about registries. There's one which is about harmonizing the way the information is collected, and how can we have different fields and different data types, unstructured data in different national registries, and can we do something to be more harmonized about how BO registries work? And maybe the guidance that we're working on can help, but maybe it isn't enough. And the other question is about the accuracy of public registries. How can we ensure that the information is accurate, and when the information isn't accurate, what can we do about it? Let me see who wants to jump in on those. I want to pick on Chiara.
think I'm the easy candidate for this one. Maybe also to share a bit what is our lessons learned on this, because it's true that actually through the current legislation we have in place, we have left a lot of leeway to member states, as Mike was mentioning, in terms of how much information they make available, what they collect. And at the same time, we had the challenge of interconnecting the information to make sure that, for example, FIUs, supervisors, or law enforcement agencies in one of our member states could access information that is held in the register of another member state. And surprisingly, it actually works, even in a context where the directive was leaving a lot of freedom to member states. I'm not saying that it's been the easiest thing to implement ever. There have been challenges to how we design the interconnection, but it's still possible. And actually for costs that are quite limited, to have systems that operate and speak to one another, and you can actually perform this kind of searches. So I think we already cover quite a large chunk of countries. If we were able to do it, there's a hope in terms of being able to, I'm not saying fully harmonize, but at least interoperate the systems and be able to find the same information. I'm not going to hide that actually one of the conclusions we drew in our recent proposals was that it would be better to harmonize that information for the EU, but I'm not saying that this is the lesson for everybody or for federal states that are, for example, planning to have registers at federal level or at the federated entities levels. This has been our experience. And when it comes to the quality of the information that is held in the register, I mean, it's true what Isabel and Mike were saying in terms of challenges when it comes to discrepancy reporting and whether that is actually an effective system. And I think I want to come in also linking with something that Emil was saying in terms of how registers are changing, because it's true that we've had something that was mostly in the direction of our repository of information, and what we're seeing is a more and more active registers. So indeed, this idea that, for example, you are attached to supervisor, you have a concept of carrying out checks that are a bit more elaborated. We have very good practices that actually give to the registers inspection powers, which is really something that we have decided to endorse as Commission in the proposals, because we think that it's truly the way forward, and you actually bring the registers from this passive tool to something that is like a quasi-competent authority, which can really make sure that the information is of good quality. So really discrepancy reporting becomes one of those bridging mechanisms, but it's not the only way of making sure that the information that is out in the register is of good quality. But I think at the end of the day, what is important is how your system functions, and figure out what is the best way within the context of your system that you can actually have the different prongs interact with one another to make sure the information is of good quality. I mean, from our perspective, of course, registers play a very central role. So we invested a lot on empowering them, and that's what we are continuing to do. But when you want to have something that is a bit more decentralized, maybe the solution is different, and you have to keep these things in mind when devising the system.
Thank you. It's one of the things that always comes up here, that registries are becoming more active and that there's a real need to verify the quality and accuracy of the information that they contain. The debate it always sparks is over who's got the responsibility of doing that, and whether it's the registry that needs to verify it or the private sector that needs to report discrepancies. So I want to come to Isabel for her views on discrepancy reporting before we move on to some of the other big changes.
Yeah, and thank you, Tom, and thank you, Chiara. I think, you know, there's things that are good practice. Yeah, clearly, if you're verifying the information and you're seeing something blatantly wrong, I think that, quite frankly, that shouldn't be a requirement to raise that in order for people to do it. I think that is fine. I think where it does get difficult for the private sector is, and not just when it comes to the clients you're dealing with, but maybe also the own corporate you're looking after. You're dealing with a multitude of different regimes in different countries. And I'm not just saying that there's these fundamental big differences, because I don't think they are there, but they are the smaller differences. You need to make sure that the people in the jurisdiction are equipped to do it on time, all these type of things, which of course, we're professionals, we can do that. But I feel at the same time, it's a little bit, I'm glad to hear this about, what Chiara touched on earlier, because I also feel that, always putting everything back to the private sector, I don't think that's going to work, right? Because at the end of the day, we have to work together. I'm not saying that every company or every financial services company is always doing the right thing. Clearly, if that were the case, we probably wouldn't need to have that conversation here. But at the same time, professionals in the industry, we want to do the right thing and we want to work together. But equally, it needs to be balanced and it needs to be sensible, because there's also situations where, and we've actually had that with a client, where we did notice a discrepancy. And in this case, the beneficial owner was the CEO and they were in the process of changing that. They had already done the right thing, provided us the correct and updated information. And, updating a registry is usually not something that happens in like half an hour or something. And I think there you also have to be a little bit prudent if you understand the client, if you understand the situation. I don't think I would want to be forced to reporting a client to a registry rather than saying to the client also, by the way, please make sure you're updated, and maybe you go in and check a week later. If it's then still not done, different story. But I think, on balance is the conclusion.
So maybe there's a takeaway for the policymakers in the audience around getting the partnership right between public and private sectors when it comes to keeping information updated. I'm going to move to a last topic which caught a lot of attention when the revised standards came out, which is bearer shares and nominees. We announced new controls on both of those because they're so frequently reported as being abused and they're so problematic in many countries. I want to ask Emil, what's the thinking behind that, and what changes are you expecting to see as a result of this?
Thanks, Tom. Yeah, so to start with a probably smaller issue of the two, which is bearer shares, which used to be a massive issue. Obviously, if one can transfer control of an entity simply by passing a piece of paper, that is the bearer share, to somebody else without any registration obligations, that is a huge hole one can drive a truck through. But I think we see that type of abuse simply fading in the background because most countries have already taken measures to immobilize bearer shares or to do away with them altogether. And the current change in the standard obliges countries to immobilize or otherwise hold them in custody somewhere and not allow non-listed companies to issue bearer shares anymore. So I think that's the smaller issue. The bigger issue is the abuse that is made of nominees and nominee constructions, whereby you basically have a nominee director or a nominee shareholder who maybe to the outside world pretends to be the real director, but is in fact acting for someone else. Now you can theoretically understand that is an issue, but also recent research that we have carried out, or rather that Professors Jason Sharman and Daniel Nielsen have carried out for us for the Stolen Asset Recovery Initiative, called Signatures for Sale, whereby they undertook what is known as a mystery shopping exercise. So Jason Sharman is sort of known for this approach, whereby he will get a whole bunch of researchers together and they will, in this case, approach a very large number thousands of trust and company service providers seeking to set up shell companies, and then see what the sort of constructions are that are being offered, what the response is, what sort of due diligence they do, and then log that. So they did an enormous exercise on that, and found that in the many thousands of approaches they sent, 14% of the service providers that they addressed their requests to, 1414, came back with some sort of nominee construction. And I think that's, you know, so it's not, my point is, it's not just a theoretical issue, it is a live issue. And also, if you look online, and I think it's a very important thing, for instance, if we do assessments, go and see what sort of advertisements trust and company service providers in the country that you're going to assess put out there. I think a particularly nice one that I just want to give you a quick quote of, just to give you a bit of a flavor, but it is quite illustrative of the sort of examples we see, is it doesn't matter, this is a trust and company service provider in an offshore jurisdiction. It doesn't matter who the front man for your corporation is, as long as it's not you. Just to keep you assured, our directors are completely ignorant to the happenings of your corporation. They will never know who you are, and unless you request it for some special cases, they will have absolutely no information about you. So, you know, that is out there. As we provide anonymity, we can, you know, keep you off any books. So I think that as an live issue is out there, and that's why the rules on nominees have been, that were previously more flexible, allowing countries their own approach. They've been made a bit more prescriptive, telling countries that they must apply at least one of three options to enhance controls, either require nominees to disclose their status and their nominator to the company and any relevant registry, and to make sure that the information on their status is public, or have professional nominees, and then the status and the nominator will be gathered by the entity in charge of beneficial ownership, or to enforce a prohibition on nominee directors and nominee shareholders. So not just have it on your books, but actually enforce that. And I think that is a big difference. So that on the topic of nominees. Thanks.
Thanks. That's very
and if I could just add to that, I think this kind of skeptical approach of mystery shopping is something that regulators and indeed intermediary companies might try themselves to try to test whether their systems are really working or not. And one can think about it in a range of different settings, not just in this one. And if one was cynical, one would suggest that its absence from general regulatory behavior suggests that some jurisdictions don't really want to know what the true state is. And that's why it's important for FATF and others to see this as part of a kind of level playing field of practice.
Thanks. This is a good point. And yeah, countries are often surprised when they see an FATF assessment team Googling resident directors or nominee directors in their country during an evaluation. They feel it's somehow unexpected. But we do look at this, and there's growing emphasis on supervision of the people providing those services as part of the wider implementation of the FATF standards. I want to move on from the core of what the changes are and the rationale for them, because changing the standards is a first step, and by far the biggest half of what we've got to do is still ahead of us, which is implementing those changes. Making laws, passing regulations, building institutions and practices and staff and training, all at national level and at company level. And I want to look at that before we move on. I want to start with the public sector side. Building a registry is not a trivial thing. So what experience have we seen in the countries that have built beneficial ownership registries so far, and what can we learn from those? Can I come to Chiara first?
Sure. And I'm happy to share the experience, because I mean, we have that of our member states, of the EA countries, and like I said, also of trying to interconnect those registers. So we have gathered over in the years quite a bit of experience on how you actually go about setting up the registers, and I'm not going to call them challenges, but more like things that you have to think of when you set them up. And I think I will divide it in 3 main groups. So basically, I would have like the existential questions, the one that you put down in legislation. So how you think the register should work, what information it has to contain, who can access what information, and how. And that actually links back to the question that we were being asked about the fundamental rights and how to ensure data protection. And I can just share from the side of the EU, we did actually give a lot of thought about that. So there is obviously all the time an ongoing debate, but you can strike a balance between what is a public policy objective, like fighting crime, and preserving a fundamental right like individual privacy. So that is the first batch. Then you actually want to think about how to shape that register. So where do you put it? Do you resort to the existing company register? Do you want to create a new register? Do you want to give it to a specific competent authority in the country? And then you have, let's say, the more mundane questions, staffing, budget that you're going to allocate to the register. And actually, you really want to have all of this 3 groups of questions well planned out before you start, and make sure that this is what makes sense for your context. It really has to be something that can then ultimately work. I have one suggestion in terms of things to avoid, and it's not to think that when you've done this, the work is done. Like we discussed before, registers are no longer passive, cannot afford to be passive, cannot afford to simply rely on the private sector telling you, hey, look, the information you have is wrong. So you really have to think that the moment it's set up, then it really has to continue functioning. The risk, if it's not keeping the information up to date, if you don't have people who can actually perform the checks and the verification, is simply that the ultimate goal, that of law enforcement that by using the register as the main source of information, will not be achieved. If they cannot trust the information, they will look elsewhere. And that inevitably slows down analysis and investigations. So even the most fanciful register, if it's not up to date, if it's not thought in a way that can fulfill the objectives of the competent authorities, it's there for nothing in a way.
Thank you. So building a registry of beneficial ownership is not trivial or straightforward, even in an advanced EU country. What chance do developing countries have? And what's the role for technical assistance and capacity building in helping them to implement this obligation? Because it applies to everyone, not just the advanced economies. Emil, do you want to take this one?
Thank you, Tom. Yes, and I want to come back to the issue we were discussing earlier, which was a risk-based approach, and the fact that you need to identify what is the issue in my country before you start taking measures. And for some of our client countries and jurisdictions we work with, indeed, there is an issue of their locally incorporated entities being abused for all sorts of nefarious purposes. But I think there is also a danger, and there is an unfortunate push in the donor community to say beneficial ownership registries everywhere at all places and any time. And I think in some of our countries, we have to acknowledge not many countries will be incorporating, not many bad actors will be incorporating or using entities incorporated on those countries because the legal system isn't solid enough, because the court system doesn't work well, because the rule of law is altogether tenuous. And if there is one thing that money launderers are very keen on it's to ensure a legal way of maintaining control, as in there has to be a legal way of me controlling it. And for many of our jurisdictions, you have to say it might be, if you want to tackle the issue of beneficial ownership, and of course we provide assistance particularly on investigations of kleptocracy, large-scale corruption, there might be more merit in helping investigative agencies and FIUs understand, getting back to that earlier issue of multi-jurisdiction, what the foreign entities are that their president, they think, might abuse, and how I get information on that, and how I work through the international channels for cooperation. Then first putting all your efforts into, we have to have a full beneficial ownership registry, because that is massive. Well, Chiara put it very well just now, and that's in advanced economies. So putting all your efforts there for maybe not very much gain, maybe there is more point in focusing on what type of, and that can, that can be typically in a lot of countries, we see that historical ties or colonial ties still count, and that certain entities in certain former colonies are abused more than others. So being aware of that and knowing those sort of channels of information may be more important than going 100% and all in on beneficial ownership registries. Thank you.
Thanks. So all roads lead to the risk-based approach. And that's the key to avoiding putting in place a lot of unnecessary structures and spending if you're not putting those on the places which are the absolute highest risk. And I guess that means the starting point for everything in advanced economies and developing countries is understanding the risks properly. We've had a lot of questions in the chat about this, and I want to turn to Mike on this. Is there a right way to start assessing the risks of misuse of legal persons? And have you ever seen a good risk assessment?
I have seen what I would regard as good risk assessments. And in a way, it's a question of, do you collect as much information competently as you would need to make the kinds of judgments about what could go wrong? And the difficulty here is that some of those risks might emerge later rather than at the time that you make them. And there's this demand for almost a kind of continuous update of risk, which puts an onus on registries to keep historic ownership data as well as current. So if your historic data just goes out into the ether and you don't store it, how's an investigator, including somebody trying to make a current risk judgment, going to be able to know, well, what's happened in the past? So that's a very heavy demand. So I would say that linking the better ones that I've seen try and link up the owners, their own backgrounds. Yeah, is given what the company's goals are, is it plausible that this person is running it? Yeah, what's the source of wealth? What's the source of funds? But this is a different challenge for, if you like, international firms, lawyers, Fidelity. I'm sure Isabel will have something to say about this, than it is a very bog standard company incorporation, whether it's in the UK or anywhere else, that costs a very small amount of money. Who is actually, for whom is it profitable or not loss-making to really do a check on all of those things? So either you eliminate that kind of corporate possibility by saying, well, we're not going to recognize it. Coming back to Emil's point, we're going to, if you like, disqualify you from legal protections in the jurisdiction. Or if not, you're asking everybody dealing with that business just to say, we don't have enough confidence to give them an account. And that could be a reasonable solution. That would wipe out a lot of the lower end of the market where they're just being used as part of a large exchange of phony transactions. But if you're concentrating on the higher value things, which is what the kleptocrats primarily interested in, then yes, check that out, and just don't have them as a client. And that means doing away with a lot of potentially profitable business.
Thanks. I'm going to come to Isabel next on that point, but I've noticed actually there have been some countries which have done the risk assessment and considered at least one form of legal person altogether too risky to exist. So they've wiped it out. But Isabel, what's the private sector side of risk assessment? And what information do you need in order to actually do your assessment at a company level? And perhaps you can also pick up on the point Mike just made about stopping doing business with customers and what might be the downsides of that.
Yeah, that's a few questions in one, but let me take them a little bit by bit. So when we conduct our own risk assessments, which are different to the jurisdictional risk assessments, because we might also have a different point of view, depending on whether we do something at local level or whether we look at it through a global lens. I might have one of my colleagues in jurisdiction X who thinks something is very risky from his local perspective. But when I look at that from a group perspective, in the grand scheme of things, I might come to a different conclusion, or the other way around, is probably more likely. So I think from that perspective, what we do is we do a number of different things. So first of all, we have in every single jurisdiction where we have a regulated presence, we conduct local risk assessments. I think this is the key, right? This is the basis, this is the foundation, because ultimately the people in location understand their business better as someone that is, maybe 1,000 miles away, maybe does not fully understand and appreciate nuances, because a trust, and I know that this is sort of has a very bad connotation, but we also have to recognize that a trust in one jurisdiction and a trust in another jurisdiction might not be the exact same thing, might not bring the exact same risk to it, not advertising for trust in any shape or form, but people do have to understand at that granular level of detail. We, at local level, we look at the products we offer, we look at the jurisdictions we service, we look at the type of clients we have, we look at sort of a variety of things, and then we bring that together at group level. Which can be a challenge, because we do different things in different countries, and sometimes you do have to compare a little bit apples and bananas. It's still fruit, but not the same thing. And I think what can probably be quite a challenge is terminology and language. You might have in a certain jurisdiction someone using a word. I think we spoke about nominees earlier and intermediaries. From my perspective, these are two very fundamentally different things and concepts and different risks, but we need to make sure we speak the same language. We need to understand that if I say a nominee, that I mean the same thing that Mike does, and vice versa. So that would be my 2 cents on this, Tom.
Thank you. That's very useful. And actually the nominees and the intermediaries point goes to a question we've had from the floor and a concern we've had a lot of times. It's about de-risking. It's very easy to write international standards that deal with a real criminal risk, but sometimes innocent people get caught up in the dragnet, so to speak. And I want to maybe ask all of the panel, what can we do to make sure that the damage to legitimate business isn't unexpected or severe, and that we don't accidentally harm legitimate activity? I'll come to maybe Emil first on this, because he's looked a lot at de-risking when we come to correspondent banking, and we're facing similar risks in this area.
Thank you, Tom. I think, yeah, I go back to what has been said many times, that a true implementation of the risk-based approach means that you can at all times interrogate and challenge a rule that is not backed up by the requisite evidence. And I fear, exactly as Mike said right at the beginning, we pay lip service to the risk-based approach, but in fact what we've done is we've taken a baseline and we stacked on top of that. So, you know, we love talking about high risk, and we've carried out risk assessments in 120 countries now, and everyone loves talking about high risk. But when you say, okay, it's about reallocation of resources, where is it going to go from? Everyone is scared of saying anything is low risk, as there's a sort of schoolmaster in all of us. We like the severe, but we don't quite dare say, oh, well, actually, this is totally okay. And you see this in many areas of the AML CFD standards. The one I'm particularly active on is more on non-profit activity. But whatever the activity is that you focus on, is there a real reason why a company or a country has adopted a certain rule, and do they have the evidence to back that up? And that requires very, very frequent interaction between public and private. And that is something that I think, you know, many FATF countries are probably quite far in that. In a lot of our client countries, there is still enormous concern on either side of engaging that debate. And so you get rules that are taken at the severest end of the scale, not backed up by evidence, that indeed end up harming the most vulnerable, or those who pose no risk at all. And the ongoing debate is a way to solve that, but getting that debate started is an enormous challenge.
Thank you. Let's see if some of the other panelists want to pick up on this point. Mike, I see your hand.
Yeah, I'd like to abandon the term red flag, except in extremis. I'd like to replace it with amber flag or yellow flag, because people use the term red flag in public and private sectors far too casually. It's quite rare that something on its own is a red flag, in combination, perhaps. So I think that might do something for de-risking, because if you call something a red flag and then the intermediary goes ahead and ignores it, then that's seen as a very negative thing. If you called it an amber flag, and you showed that you'd taken account of it, that would be an easier thing to do. And national regulators, even prosecutors, might take note of that point as well, and clamp down less hard in that situation. And in that way, there would be less of a temptation to de-risk. But some of the de-risking takes place, as our research has shown, because you have to do so much due diligence that the client is no longer profitable. And we have to accept that, and perhaps try and work out what we can do about it. But certainly for non-profit organizations, it's possibly more of an issue when they're suspected of terror financing risks than of other things. But even for ordinary things, people look at what the big international firms are doing, and if they say there's a red flag on this country or on this jurisdiction, then they might feel they just can't deal with it, and then you get less competition, and it's really bad for development.
So important for people to be aware of this when they plan at national level. We are almost out of time. We have, I think, 4 minutes left. I'm going to directly answer some of the questions that we've seen in the Q&A, because yes, this whole chat is going to be up on YouTube later for other people to watch or download at their leisure. And we are still actively working on very detailed guidance on the beneficial ownership requirements, which we're hoping is going to be published either in October or in February, depending on how quickly we can all agree. So that, I hope, will answer a lot of the questions that we have seen in the Q&A about things like adequate, accurate information about the difference between ownership and control. So we're not finished answering your questions, but some of the more of them will come out in writing in the next month or two. Before we wrap up, I want to go quickly around each of the panelists and ask them what they think is the most important change and what they think is the most important challenge that we've still got ahead of us. And I'm going to see who volunteers to jump in first. Chiara.
Why not? So change, I don't want to point to a specific one. I think even from the perspective of youth or advanced economy, what's really important is the holistic approach that has been taken, which will force us to reflect on our entire system, see where we can fine-tune what we've done and where there are areas that we need to get improvements as well. So I really think that's the important aspect, the fact that we look at this matter holistically. And the challenge, I think, it's something we've already touched upon today in the discussions, which is to keep in mind that this has to be a flexible, risk-based, and then you might need to revisit it over time. You have to adjust to new trends in criminal activities. You have to make sure that you remain proportionate and therefore never think that you've found the Holy Grail in a way, and just try and keep that mind open to make sure that you can adapt as needed.
Thank you. Who wants to go next? Isabel.
Thank you, Tom. Yeah, I think from a private sector perspective, and again, it depends a little bit from which lens you're looking at this and from a jurisdictional lens. So, I mean, I'm European. If you talk to me about beneficial ownership registries, well, that seems a little bit like yesterday's news. But if I come from that, from like my global role and look at the other jurisdictions, that's certainly a big one. I think, yeah, from a private sector, and I did say this before, I think the risk-based approach, the balance is important because we cannot endlessly do more and more because you need to focus. And I think that is key. I think language is key and understanding the details of some of the concepts. And that they might, in some circumstances, fully apply, and others we're actually talking about something fundamentally different. And I think that's sort of what I talked about earlier about we're all in this together. I mean, I'm not suggesting we start singing a song together, but I think it's so important, right? Because people in my profession, we do this every single day. We know our customers, we know our products. And if we don't, we are the ones that are there internally to ask the stupid questions, and we do. And I think it's important that we do work together because we have the same aim, so that, you know, we don't end up somebody using a certain term in a certain document that then other people don't understand and potentially harm, you know, Emil and Mike touched on it earlier, harm legitimate businesses, harm legitimate clients, because ultimately financial services, we also have an obligation to protect our clients, right? And to make sure that they get adequate financial services. Because if everyone's de-risking absolutely everything, then, you know, certain people, and in particular, in maybe the type of people that we wouldn't want to be targeting, do not have access to that, and that is not sustainable.
So the takeaway is we need to work in partnership so that we don't accidentally break something important. I'll come to Mike. One big change and big challenge.
Okay. data science needs to be used better to look, for example, at the plausibility that person X should be a beneficial owner of 200 companies. And to do that, you need to be able to search on their name in different jurisdictions. That's just a very simple example, but better data linkage between registries. And we need more public investment in registries and both their compliance testing and their enforcement. Because if they're not enforced, then people will stop taking it seriously and nobody will be able to rely on it. And there's no point in this big change, which is a good change, unless we can rely better on the data that we have around.
Thank you. And last word to Emil.
Thank you, Tom. Yeah, I think I would echo sort of Chiara's points about realistic expectations about what can be achieved. In the Puppet Masters, we quote Secretary of the Treasury Morgenthau, who already in 1937, so that's 85 years ago, complains about dummy incorporators, foreign lawyers incorporating these weird entities to hide the persons of interest. So this issue has been with us for a very long time, and to some extent we're playing whack-a-mole. You know, you solve one problem here and a problem somewhere else arises. That isn't to say that we haven't made a lot of progress, because I think we have, and I think it has driven up the costs for criminals and bad actors. So I think we should absolutely keep at it, but don't expect results tomorrow. This is the beginning of a very long journey ahead. Thanks.
Thanks. I think you've picked up my big takeaway, which is this is the first step of a very long journey. And we can't sit back and relax on this. Partly, as Chiara said, we've got to be flexible and dynamic, because as soon as we answer the question, the criminals will change the question and we'll be looking at the wrong answer. But also building a partnership and building investment so that we can make these things happen in practice is very important. I've also heard that some people saying there's not much disagreement among the panel. My take is we're all moving towards the same destination, and that's very good, but we all have slightly different roadmaps and routes for getting there, and I think there's a lot of difference in emphasis about who does what. But that's under the surface, and we haven't had time to go into it today. We're due to wrap up. I want, first of all, to give huge thanks to our panelists for sharing their wisdom and their insight with us today. And thanks to you, the audience, for the very insightful questions that we have been struggling to keep up with. I hope we will be able to answer some more of them in the future. And that this session has been a good way of getting an insight into what the new standards meant and what more you can expect in this area. Thank you to the panelists, thank you to the audience, and goodbye.